So something had to give, and it was either the judge's bench or the lawyers or counsel table. Since I suppose you got the short. All right, so we are on my civil docket. I am providing public access not only in the courtroom but also online. Just want you folks to know that. And we are here today. Looks like defendants Bruckman filed a motion for summary disposition. I reviewed the plaintiff's response. Defendants Coveton and Cisco filed a response in support of that. Plaintiffs filed a motion to strike that initial response for seeking relief for those defendants without a separate motion. It looks like, and there's responses to that motion to strike, but it looks like defendants Coveton and Cisco filed an amended response that maybe fixes that problem. All right, so let's have counsel state your appearances for the record, beginning with plaintiff.
Yes, Your Honor. Joseph Sias on behalf of Mr. and Mrs. Holderman.
Kevin Cleaborn, I represent Mike and Becky Bruckman.
Lawrence Hanson on behalf of Mr. Cisco and Mr. and Mrs. Coveton.
Okay, and is Richard Reeves present? No, and is Doris Reeves present? Okay. Mr. Reeves is representing himself, filed a letter answer. It wasn't signed by Doris, so there was a default entered on her, but they are both in pro per. Okay, so Mr. Zayas, I guess my first question is, does the amended response address your concerns? And we're not going to hear argument about striking their initial response.
Only if, Your Honor, that the defendants aren't going to request summary disposition on their own behalf.
Well, I don't know, because I guess my other, and I don't want to jump the gun here to I want to hear argument from all sides.
Sure.
But if Bruckmans are entitled to summary disposition, wouldn't everybody? I mean, these are co-tenants.
Right. I mean, there are some similar issues. I understand that. My real issue.
Similar. How would they be any different? The court rule says if I conclude that the facts are such that a party's entitled to judgment, then I should enter it without delay. So if Bruckmans prevail today, it seems to me all the defendants would prevail today. Why would there be any difference if they're co-tenants?
My real issue with the pleadings that the Cleaborns filed, Your Honor, was the fact that they added additional arguments. In fact, even adding additional case 3 days before my response is due. If they simply filed a concurrence saying exactly what the court just said, I think it'd be a completely different situation. But when you shorten the time I have to reply by 2 weeks by adding additional arguments and even referring to another case, then I think that's a different matter. And that is my real issue with the Cleaborns trying to kind of add themselves onto this. It wasn't a simple, yes, we concur, us too. It was, here are these other arguments that why we should grant us summary disposition, which are not exactly the same as what the Bruckmans filed.
Oh, okay. All right. Well, and I know there was a response to your motion to strike, and so you all, or many of you, seemed to care a lot about that. I want to assure you, I cared very little about all the details of when it was filed and whatever. I read all this stuff. You all did a great job filing all this stuff. So I am much more interested today in the, you can make whatever arguments you want to make. I am much more interested today in the substance on whether the Bruckmans are entitled to summary disposition. And it seems like if they are, that's the first domino and everything falls after that. So that would mean it's your motion, Mr. Cleaborn.
Thank you again. Good morning again, Your Honor. It seems like from the plaintiff's view of the world, they pled adverse possession, hostility, et cetera, time and time again. But the facts at their depositions just shout loud that there is absolutely no element of hostility whatsoever. And any kind of claim like that has to be inconsistent with the rights of the defendant. And so is there anything anywhere where the use of that drive was inconsistent with the rights of the defendants? And the answer is no. The issue of even the extension of that drive onto the plaintiff's property, Plaintiff Rich Halterman testified, well, I put that in for Mr. Coveton's father, Grandpa Coveton. He never said, well, I did it because I wanted to, I did it because I need to, or anything like that. The plaintiff, Julia Halderman, testified it was for the defendant's guests. And so even that extension of the drive onto their property from the upper level was not done under a claim of right. And so, you know, every case that's out there having to do with this type of prescriptive use claim has some kind of element of hostility. And there just isn't any. And so when we go back to the records that we attach to our motion, where the Bruckmans have records of gravel dating back to 1994, and then the plaintiffs have nothing. I mean, the only thing that they've produced with regard to any kind of documentary evidence at all is the purchase of an Argo and a Kubota side-by-side. And so it just seems to me that there's just nothing. And so when the plaintiffs admit, yep, we're friends and we do it all together, and they really have no comeback even to anticipating their best argument. Gee, we bought in 1984 in land contracting, so we were there before you. But when Mr. LeBron testifies, I put up a lock and cable while I was there for the 6 years, and I never saw the plaintiff using it at all. Again, there's no continuous hostile claim of right, 15 years, etc., that the plaintiff would have to establish to take away a property right of the defendants. And so, again, when I'm glad that counsel plaintiff attached the deposition transcript of Julia Halderman. So at page 25 of the deposition, she testified when I asked her a question about, how does the whole gate kind of thing. She said, normally we'd ask them, meaning the Comptons, permission to open the gate. Can you please open the gate? We need to get down. Well, my goodness, there is no hostility at all. If they're best buds with a 1/4 owner of the tenant in common property, then again, there is nothing that the plaintiff has shown, even an iota of a claim of right type thing to take away a property right.
So can I ask you, in your motion, you spend a lot of, you spend some amount of space documenting the friendship over the years between some of the parties. And at first blush, seems the plaintiff in the response was making a fair point that the hostility element is a legal term and not a term of emotion. So maybe you can help me nuance that. You're not saying that because they were friendly that defeats a claim of hostility, but that therefore it wasn't against their interest under a claim of right because it was a cooperative use? Is that?
Yeah, so I think the case that they cited a couple of times, that Munro versus Riddle case, was their primary argument with regard to, well, gosh, the one owner of the property knew that the drive to the neighbor cut across the corner, and they didn't do anything about it. They never discussed it. They basically let it go. But again, that was not a case that they're relying on. That was a shared driveway issue. And that's right.
But you'd acknowledge that hostile use doesn't mean angry use.
No, it doesn't have to be,
use.
it doesn't have to be in your face type thing, but it still, throughout every case out there, has to be inconsistent with the rights of the defendants in this case. And so, when there is, we're having parties all the time, we're best friends, etc. And it just speaks to the volume of evidence that is on the defendant's side with regard to the permissive use. And again, the Munro versus Riddle case was just a corner of the property that was used exclusively or primarily by the neighbor. And that's why I thought that case was easily distinguished. The only thing that I could add to what I tried to provide to the court is with regard to our claim for summary disposition on the riparian rights issue. I finally found a bigger, better plat that's clear of Vincent's plat. I do have a copy of it I could share with the court. I had a really poor blow up copy, but here's the primary issue with regard to our trespass claim. I tried at Mr. Halderman's deposition to get him to appreciate the issue that the riparian survey was measured from the section line 105 feet. And so if you look at lot 15, can you see where there's a little arrow and there's 13.72 feet to the south of the
Yes.
section line? So that's where, again, I can't win a case of deposition. I just need to try to establish facts. And I finally raised the white flag and gave up trying to get him to appreciate that the riparian survey that we have prepared went 105 feet from the section line north to establish the fact that their dock was trespassing in the defendant's lake space. And so it's just a bigger, better, clearer issue with regard to what was the debate at his deposition of did their dock offend into the defendant's lake space or not. And then when counsel went ahead and argued, well, gosh, the dock isn't there anymore. I mean, everybody can see the dock that they've put back in. This year, they've since the lawsuit was pending, 24 and 25, they put the dock out, they put the shore stations out, they've got the stuff in the water that they always had. So to argue that, you know, it's not there anymore, it didn't make sense to me. I was really confused.
And your counterclaim, do I understand right? That's based on, well, here we've got this riparian survey and there's really no countervailing facts submitted by the plaintiffs other than saying they just disagree with it.
Correct, that's it. So, I mean, it was riparian surveys, as the court probably knows, are not cheap things. So we went ahead and had one commissioned in 2024. And again, the admission at their deposition was, yep, for the last 3 years, we've gone out from the same point just inside their property line and have angled out into the water. And so it just seems like, you know, it may be not tens of thousands of dollars worth of damages, but obviously when they trespass and put their dock on the bottomlands of my client, and then, you know, more boats on the side of the dock, it takes up more lake space. There is an element of damages to that. So I wish we would be all done here today, but I would ask that the court dismiss the plaintiff's complaint. And again, just set a hearing for our counter complaint for the riparian space intrusion.
Thank you. So I think in the interest of allowing a joint kind of response, I'd like to first next hear from Mr. Hanson on his concurrence in the relief, and then I can hear from you, Mr. Zayas. Go ahead, Mr. Hanson.
Your Honor, you indicated that you read the response and the amended response that incorporates the additional arguments that I thought were perhaps useful. And
yes, sir.
I would again just emphasize that the relationship, friendly relationship between the parties is a central issue here in terms of the hostility that is required. Page 6 of my brief, I cited the Wango case in which the hostility issue, the true owner must have actual knowledge of the hostile claim, or the possession must be so open, visible, and notorious as to raise the presumption of notice to the world that the right of the true owner is invaded intentionally with the purpose to assert a claim. We didn't have any testimony, Mr. Holderman or Mrs. Holderman, that they at any point got to in their relationship.
The defense leans hard on the idea of permission versus hostility. They argue the Haldermans weren't hostile occupiers, they were friendly neighbors who openly asked for access when a gate went up. Legally, hostility doesn't mean anger, but it does mean using the land as if it were your own, against the true owner's rights. If you're asking permission, can you still claim a hostile right later?
Relationship with respect to use of this, where they announced that they were now claiming this is a hostile right. This is different than a neighborly situation. This is more like a family situation. Can you have a family member living in your property with you for 25 years, file a claim for prescriptive easement to continue to stay in the property? I thought that the concept of unclean hands breaches that, which is why I briefed that. So I have nothing further at this point.
Thank you, Mr. Hanson. Mr. Zayas?
Yes, Your Honor, thank you. Again, Joseph Zayas on behalf of Mr. and Mrs. Holderman. And the first thing I think I want to point out is when counsel says that Mrs. Holderman testified about getting permission to go around the gate, that gate only went up 2 or 3 years ago. They have been using this road on a continuous basis for the last 40 years. And at the end of the 15-year period, that's when the right vests. So whatever happened after that gate went up is frankly irrelevant.
Well, I mean, it might not be dispositive, but it seems a bit much to say it's irrelevant, because if your clients had a claim, if she pulled up to a gate and said, open the gate so I can use this road, because it's, if it wasn't some asking permission, the asking permission is, if we have a trial, that would come in at the trial because it would be relevant, right?
Yeah, it would probably come in, but I would argue that it certainly, perhaps I misspoke, Your Honor, certainly wouldn't be dispositive of whether or not it was permissive use or
I
not.
agree, yes. Okay.
Frankly,
There's some evidence of it.
maybe.
She's asking permission. Why is she asking permission if she doesn't need permission?
Well,
That would
frankly,
be
I would
the-
argue, Your Honor, that that's more trying to keep the peace between the parties after they have kind of staked their claims and we filed a lawsuit trying to get this than anything else. I know the court certainly disapproves of self-help tactics. And once the gate went up, my client simply said, okay, we're going to exercise our rights under the court to try to get access to this road again.
Okay.
Now, my argument, Your Honor, is that at 15-year period, their rights vest. So, it's not evident, or it's not evidence of permissive use within that first 15-year period, certainly. And I think that's important to point out. So the most important thing here is I think we need to realize that we must take the facts in the light most favorable to my clients. We're looking for questions of fact here. And I think when you take the evidence in the light most favorable to Mr. and Mrs. Holborn, we see that they've been using this path since they purchased the property in 1984. They both testified very clearly to that. Now, counsel has attached an affidavit from a prior owner saying, well, he put up a string, he put up a gate. He certainly didn't, confront my clients with that affidavit during their deposition. If anything, he's created a question of fact because my clients were very, very clear that they used that continuously since they bought the property in 1984 when they started to clear their property. So taking those facts in the light most favorable to Mr. and Mrs. Holderman, it establishes that they started to use that they continuously used that property. Now, if anything, what that affidavit does is show that use was hostile. It certainly shows that the prior owner didn't give any sort of permission for them to do so. Nothing within the affidavit suggests such a thing.
But even if you were right on that, that wouldn't establish the 15-year period is not established just through that.
No, I'm getting there.
So then how do you overcome the whether you call it permissive use or it wasn't hostile, it's sort of two sides of the same coin, where here's this outlot that by deed doesn't give your clients a right to use it. It gives these other folks a right to use it. And those other folks and your clients together are improving the roadway. The owners are buying the materials and your clients doing some grading. They're all kind of using that together. How does that ever establish a right